Assalamualaikum, everyone. Thank you for joining us. Welcome to our third episode of Know Your Rights. Our speaker for today is Tobin Raju. He is an attorney, First Amendment fellow at the Washington University in St. Louis School of Law. And we are joined by Theodore Van Beek. He is a student at Washington University of St. Louis, and our very own Masha, who is a board member.
Great. Well, I'd like to thank CAIR for the invitation to speak to you all today and to share this presentation on the First Amendment right to peaceable assembly, and just to share a little bit about the First Amendment Clinic. So I'm a graduate of WashU Law School, actually, and I joined the clinic last summer. And before that, I practiced at a law firm in New York, where I focused on First Amendment and media litigation. The First Amendment Clinic at WashU is one of several legal clinics at WashU Law. And the clinic is directed by Lisa Hoppenjans. And each semester we have 7 to 9 law students who work on the clinic's cases under the supervision of Lisa and myself. And today, as we mentioned, I'm joined by one of our great students, Teddy Van Beek. So our clinic provides legal assistance to organizations, students, journalists, and citizens in matters implicating the freedom of speech, press, and assembly. We also represent journalists in actions to enforce statutory rights of access to public records. So some of our recent cases include representing a resident of the city of St. Louis in a lawsuit against the president of the Board of Aldermen for blocking our client from his official Twitter account after she tagged him in a tweet questioning one of his policy positions. That lawsuit is ongoing. We have a summary judgment motion that's still pending in that matter. We're also representing a well-known artist in a lawsuit filed against the city of St. Louis. In that case, our client painted a mural on her own private property that commemorated the racial justice protests in the aftermath of the murder of George Floyd. The city then went onto her property and destroyed that mural by painting over it. The city did this pursuant to a graffiti ordinance that defines what qualifies as graffiti very broadly. The ordinance does not provide private property owners any opportunity to challenge the city's determination that an image is graffiti, even if the property owner was the one who painted it on her own property or wishes to maintain the graffiti, alleged graffiti, on her property. In another case, we sued University City on behalf of 2 musicians who regularly perform in the Del Mar Loop. That lawsuit challenged University City's obstruction ordinance and related policies that prohibited our clients from playing music on public sidewalks and in private areas near public sidewalks. University City had a policy of forbidding individuals engaged in speech from remaining stationary on public sidewalks. Essentially, in order to play music, one would have to be walking while doing so. So unless you're in a marching band, it's pretty difficult to play music when you need to keep walking. And that policy was applied to a wide range of individuals, including a children's dance group, carolers, and individuals sharing their religious views on the Del Mar Loop. Recently, we had a big win in that case where a federal judge ruled that University City's non-stationary policy violated the First Amendment and due process clause. And now Teddy will tell us about one of our other cases that he's currently working on.
Sure. Thanks for having me. First of all, I really appreciate having the opportunity to speak about First Amendment issues. It's really important. The case that I'm involved in involves a variety of protests that occurred following the death of George Floyd, or the murder of George Floyd, excuse me. And following that, in those protests, a St. Louis police officer named Joshua Smith drove into a crowd of protesters and began beating a protester after running them over with his car. And so that sparked up a variety of protests about policing here in St. Louis that were very peaceful and that had continued on for most of June and through July. And the Florissant Police Department, or the police department here in the city, had decided that after a couple of days of protesting, that they had enough with the protesters protesting outside of their police station, and they repeatedly declared unlawful assemblies. And as a result of that, they had engaged in physical force with the protesters using riot gear. They had chemically retaliated against multiple protesters. And that was even though they had set up a variety of designated protest zones. They covered up paintings on the street that said Black Lives Matter, and a variety of other sorts of actions like that, all of which we think violated the First Amendment. And so we brought suit against Florissant, or the city, for that. For those violations.
Great, thanks, Eddie. So I'm just going to share my screen here. 1 second. Great. So the First Amendment protects a wide range of rights. It's one of the hardest working amendments of the Bill of Rights. And the First Amendment contains 2 clauses that relate to religion, the Establishment Clause and the Free Exercise Clause. So our clinic doesn't really address issues on those first two clauses. Our clinic focuses on the Free Exercise Clause, the Press Clause, Assembly, and Petition clauses. Sometimes there is overlap when religious speech or religious assemblies are involved. Of those 4 clauses that we work on at the clinic, the one that by far gets the most attention is the Freedom of Speech Clause. The Freedom of Assembly Clause, which people would normally think would more so apply to protests, it's equally as important, but unfortunately doesn't get a lot of treatment and is not often addressed in a lot of case law. Courts tend to analyze a lot of these issues under the Free Speech Clause. It's also important to remember that the First Amendment is a restraint on government actors, not private entities. So just to give a bit of historical context about the right of peaceable assembly and rights that protests enjoy, protest has been a key part of this country's history, from dumping tea in the Boston Harbor to the racial justice protests of 2020. Social movements in this country consistently rely on the collective tool of protest to accomplish their goals in peaceful ways. The right to protest is a core right protected by the First Amendment, and courts recognize that criticism of public officials lie at the heart of the First Amendment. In one early case that acknowledged the importance of the right of peaceable assembly, Portland police in 1934 arrested a member of the Communist Party who had spoken at a meeting of approximately 150 to 300 people who were protesting police brutality. He was arrested not for anything he had done or said at that gathering, but because he was affiliated with the Communist Party, which had previously been identified as advocating certain lawbreaking in the area. The court explained that the freedom of assembly can't be denied without violating fundamental principles of liberty and justice, which lie at the base of all civil and political institutions. Essentially, what the court was saying is that the right of peaceable assembly is essential to the existence of our institutions because it allows us to effect change from those institutions without the need to resort to the use of force or violence. Now, that principle was revisited in a later case coming out of the civil rights era, which protected protesters' rights. In that case, Edwards v. South Carolina, in 1961, a group of about 180 students walked from a local church to the South Carolina State House to protest discrimination against Black Americans. When they got to the State House, more than 30 officers were there waiting for them, kind of surrounding them. The protesters walked into the State House single file in a very peaceful manner, and they carried signs denouncing segregation. The protesters did not obstruct any pedestrians or vehicular traffic, but the police told the protesters they needed to leave within 15 minutes. The protesters did not leave, and instead they started singing the Star-Spangled Banner and other religious songs. The police then arrested the protesters for breaching the peace. Protesters were later convicted of breaching the peace, but the Supreme Court reversed those convictions, ruling that the students' peaceful protest was protected by the First Amendment. And since then, the Supreme Court has determined that many other types of protests are protected under the First Amendment. In 1969, in the Tinker case, the court held that suspending students for wearing black armbands in protest of the Vietnam War violated the First Amendment. In the Claiborne hardware case, the Supreme Court held that a civil rights boycott was a protected form of speech that is entitled to protection under the First Amendment. And in Texas v. Johnson, in 1989, the court held that a protester was protected from criminal prosecution for burning the US flag. And more recently, in 2011, in a case involving the Westboro Baptist Church, that the court held that their protests were protected under the First Amendment, even though some of the messages they were sharing were very abhorrent and hateful. But the analysis in all these cases didn't necessarily focus on the right of assembly, but rather the right of free speech. And over the past several decades, courts have treated the right of assembly kind of as a subset of the right of speech, which has created some uncertainty about what protections protests enjoy and has kind of limited the extent to which the First Amendment protects certain activities that happen and occur at protests. Now, what does all that mean on a practical level? It can depend on the circumstances on the ground, because protections for speech and assembly are not unlimited. What you can say at a protest. So one byproduct of the court's preference for analyzing these issues under the free speech clause is that there are robust protections for what you can say while you're at a protest. Generally, the First Amendment prohibits the government from placing restrictions on the content of your speech. Those types of regulations are considered content-based and presumptively unconstitutional. Content-based restrictions discriminate against speech based on the substance of what the speech is communicating. For example, a law or policy that prohibited any protesting concerning the police would be content-based because it singles out speech on a particular topic and subject matter, being the police. Laws that single out particular viewpoints are also presumptively unconstitutional. For example, a law or policy that prohibits people from being critical of the police, but allowed speech that was favorable to the police would be viewpoint-based because it discriminates between two views on a single topic. Your speech generally cannot be regulated because it's unpopular, offensive, or even hateful, but there are certain limits on what you can say. The First Amendment doesn't protect speech that constitute fighting words, incitement to violence, true threats, or obscenity. Now, fighting words are face-to-face communications that are directed at a particular individual that would obviously provoke an immediate and violent reaction. Incitement is speech that is intended to and likely to provoke imminent unlawful action. For example, a speaker who urges an angry crowd to immediately attack someone or destroy their property would qualify as incitement. Now, the speaker must intend to actually use words that rally people to take illegal action, and the danger must be imminent, not something that might occur down the line. And the words that are used must be used in a situation in which violence is likely to occur. True threats are statements where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual, basically a real threat that someone wants to do harm to another. And obscenity is not how we would typically understand obscenity, what it would mean. It's not, vulgar language or profanity. It's something a little worse. Usually it involves pornography or things that appeal to our prurient interests, basically our most base interests, and something that doesn't really have any artistic or literary value. Where you protest has an important impact on the protection that the protest enjoys. Protesting on private property is generally unprotected by the First Amendment. Property owners can make rules for speech on their own property. And another thing to consider is that not all public property is necessarily open to protest. Your First Amendment rights are strongest in areas known as traditional public forums. Those areas include streets, sidewalks, and parks, just because historically those have been areas that have been thought of being very important for sharing ideas and communicating between citizens and discussing issues that are important to society. And that has its basis in common law and tradition. So traditional public forums, in those forums, the government cannot discriminate based on your views, and it can only regulate based on the content of your speech if it has a very compelling reason to do so and does it in a very tailored, exacting way. The government cannot restrict speech completely in a traditional public forum, and it also can't completely restrict protest in a traditional public forum. However, in traditional public forums, the government can impose restrictions that deal with the time, place, and manner of your speech. Some examples of time, place, and manner restrictions include setting limits on noise levels and setting limits on amplified speech, if you want to use a speaker, for example. Limiting the number of protesters that can gather in a particular area, setting times for when protesters can gather and when demonstrations are allowed. An example would be when police impose a curfew. As long as you have notice of the curfew, police can order you to leave if you are violating a curfew. Government can also set limits on the size of signs that you might carry while you're protesting. But those time, place, and manner restrictions need to be narrowly tailored and leave open alternative means for people to convey their message. There has to be some way for you to get your message across, and the restrictions can't be so onerous where they effectively prohibit you from sharing your message or gathering and protesting. Your speech is also likely protected in areas that are known as designated public forums. These include plazas and public squares that are in front of government buildings like courthouses and state houses. You can generally protest in these areas and you enjoy some of the same protections you would have in traditional public forums like sidewalks, streets, and parks, as long as the space remains open to the public and you're not blocking access to the government building or interfering with the purpose of the property. One issue that comes up a lot is whether you need a permit to protest. Generally, you do not need a permit when protesting. However, because the government can enforce those time, place, and manner restrictions we just talked about, it does have an interest in preventing interference with traffic. And because of that, you might need a permit in certain situations. You may need a permit if you want to use sound application, or if you want to participate or organize a march that might block pedestrian or vehicular traffic, or if you want to use a area, a public forum, or a limited public forum to hold a large rally, you would need a permit in that situation as well. The government can set certain restrictions and requirements in order to obtain the permit, but those restrictions need to be related to their interest in maintaining public safety and controlling traffic. Some permits must be applied to several days in advance of the protest or the event. However, the First Amendment requires exceptions to those deadlines in situations where a protest is responding to breaking news or an event that has just happened. Protests don't need to, you don't need a permit if you're staying on sidewalks and you're not obstructing pedestrian or car traffic. If you are blocking car or pedestrian traffic and you don't have a permit to do so, police can ask you to stay on the sidewalk or let the pedestrians pass. So if you're getting a permit, what fees can the government charge? There are First Amendment limitations on the types of fees the government can charge for permits. Those fees can't exceed the actual cost to the government to regulate speech at the event. The government also can't charge you more when additional police are required to control groups that might oppose your speech or oppose the protesters there. The government also has to offer an exception to those fees they may charge for groups and individuals who cannot afford to pay those permit fees. What can you do while you attend a protest? While you're at a protest, you're allowed to approach other people and hand out leaflets, petitions, and other literature. But in the course of doing so, you can't prevent people from walking past you or using the sidewalk. The First Amendment also does not protect violence or any criminal activity, even when done while expressing an important political message or as part of a larger political social movement. You also have the right to record at protest. I would argue that your First Amendment rights enable you to record and photograph police in public while they carry out their duties. If your recording interferes with police operations, they can ask you to move. So that's why it's always good practice to record from a safe distance so you don't interfere with any police activities. Now, unfortunately, the law in the Eighth Circuit, where Missouri is not clear on this issue. And the Supreme Court has yet to rule on whether there is a First Amendment right to film police in public. But most federal courts of appeal have recognized this right. The Eighth Circuit hasn't expressly held that this is a First Amendment right. And in 2017 ruled that there is no clearly established right to walk into a police station to film police officers. Now, that decision doesn't apply to recording police in traditional public forums, but it hasn't really helped clarify the issue. There's also a right to photograph and record other people who are attending protests and are in plain view while they're in a public place. One important thing to remember is that police are not authorized to make you delete your recordings or confiscate your recordings and pictures without a warrant. What about counter protesters? So,
Sorry.
oh, go ahead. Sorry.
I have a question. Are they allowed to search you without probable cause?
So police can search you if you have reasonable suspicion that you are engaged in some type of criminal activity. Police sometimes might ask you if you consent to them searching you. You do not have to provide consent to a search, but if police can establish they have reasonable suspicion or probable cause, they can go ahead and conduct a search anyways. But the simple act that you're recording or present at a protest and expressing your First Amendment rights would not constitute reasonable suspicion that you're engaged in some type of criminal activity.
So I think the question would be like that girl who recorded George Floyd's murder. I mean, the police would have no reason to ask her to delete that video. She was just standing across the street and recorded that whole encounter.
Oh, yeah, I completely agree. From the video I've seen of that entire incident and her recording what had happened to George Floyd, she is in no way interfering with a police, action. She's out of the way. She, in my view, absolutely had a First Amendment right to do that.
But usually when you don't give them consent to search your bag or whatever, they always end up saying, are you not willing to cooperate with the law enforcement? Like, what are you supposed to do then? Like,
right. So they can ask you for your consent. And if you withhold that consent, one of two things can happen. They can just go about their day and not bother you. But often what happens is things escalate and they decide they're going to search you anyways. Now, if that happens, you should not generally resist, comply as much as you possibly can. But what is helpful is if you want to then later challenge that search or challenge something that was found during that search, you can use the fact that you did not consent to that search in your favor. If you consent to that search and they find something, even if that search was unlawful, because you consented to it, you can no longer challenge it. So it's important to make it known that you are withholding your consent before they go ahead and search you.
how many times has that challenge been favored in the civilian side?
I don't know. I don't have good statistics on that. These are really difficult cases. It's hard to prove, and unfortunately, the way
It does happen.
it does. I do remember. It's been a little while, but I do remember reading some cases in law school where it has happened. Maybe Teddy might be a little more familiar. He might be closer to it. But yeah, it does happen.
So Tobin, would it be fair to say that if you're withholding your consent, you should repeatedly say, I'm not consenting, so it's clear to the other party that I am not okay with this. So in the event you do challenge it, that's there, your objection.
Yeah, I think it is helpful. And as with many police interactions, I think it's helpful if you can record it in a way that is not interfering with a police action. A lot of times when you're recording and the police then decide to detain you or arrest you, they might, try to grab your hands to put you in handcuffs. And in that situation, you should not resist, allow them to do what they're going to do. But to the extent you can, it's always helpful to record interactions you may have with police officers if you feel uncomfortable. Repeatedly making known that you might not be consenting to a search, I think that would be helpful, but be careful that you're not doing it in a way where it can then be considered resisting arrest or some kind of other infraction where you're refusing to obey a lawful police order.
Okay.
So the rights of counter-protesters are also protected by the First Amendment. Protests often attract the attention of individuals who disagree with the message of the protest group. And the First Amendment protects the rights of those who dissent with the opinions of the group who is initially protesting. They're allowed to occupy the same general area, but counter-protesters cannot drown out the other speakers or physically interfere with the other protesters. Police are allowed to keep opposing protest groups separate in the interests of public safety, but generally should allow them to protest in the same vicinity. One issue that arises a lot when there are counter protesters or, ideas that are controversial or shared is this concept called the heckler's veto. So sometimes when protesters are sharing controversial messages, an individual might react violently to hearing the protester's message. I'll call those people hecklers. Police are allowed to protect the protesters' First Amendment rights by restraining or even arresting a heckler if the heckler, decides to try and physically interfere with or disrupt the protester or attack the protester. The police cannot, however, punish the protester for the violent reaction of the heckler. In an early case, for example, the Supreme Court reversed the conviction of a controversial priest when his racist speech resulted in a violent speech from counter-protesters who threw bottles and stones at the auditorium where he was speaking. And then later in the 1960s, the Supreme Court reversed the conviction of a civil rights protester when his protest in front of a mayor's home opposing racial segregation attracted a large group who were in favor of racial segregation and did not appreciate the protests. That group got very rambunctious and grew violent and resulted in some violence from that crowd. And the police later arrested the protester for disturbing the peace.
Hey, Tobin.
Yeah.
What should someone do if they're at a protest and there's perhaps counter protesters that might be pushing the line for what might be acceptable or hecklers that are getting violent? If you're just an average person at a protest, kind of what should you do in that kind of situation, knowing that you can't get violent, you can't restrict your protest because of their violent reaction. What does that situation look like?
Yeah, it's tough. It's tough because their speech is protected, but their violent actions aren't. And I think in that situation, it's very fair to approach any police that may be present and alert them that the conduct of these hecklers is no longer protected by the First Amendment. Their speech has crossed the line into something that is either violent or about to be violent. If there aren't police present and you aren't able to diffuse a situation, sometimes it might help to step away, try to avoid those who are becoming violent. But it's tough because you also, as a principal, don't want to allow people who are violent or who are going to try and hijack a protest to chill your speech. But it's also important to do what you need to do to be safe and comply with the law. But yeah, it's tough. And you see the issue a lot. And I think in the summer of 2020, you would often see people peacefully protesting in support of racial justice. And you would have counter protesters who weren't so peaceful trying to, impede upon those protesters' rights and basically create a situation where the protest is no longer safe and no longer deemed peaceful, and then the police have to come in and shut it down. And that's what the First Amendment's worried about, people hijacking protest movements because they don't like the message it's sharing and getting the police to shut it down. And it's tough, and it's a hard issue to legislate. It's a hard issue for police on the ground to try and regulate as well. But at the end of the day, it is your right to be there, even if it attracts a group who really hate your speech. It's your right to be there. And the police cannot ask you to leave just because people who aren't following the law are becoming violent. So, as we've discussed, there is a recognized right to peaceful protest that is core to the First Amendment. But there are limitations to that right. When lawbreaking or interference with pedestrian or vehicular traffic occurs, police can take steps to prevent or punish that activity. Because the majority of protests are peaceful and the overwhelming majority of those present at protests tend to be peaceful individuals who are not breaking the law, the appropriate way to deal with lawbreaking is for police to focus on those individuals who are actually engaged in wrongdoing. But unfortunately, very often, police will use isolated incidents of lawbreaking as a justification to declare an entire protest to be an unlawful assembly. And in that situation, they can then order all the protesters, even those who haven't done anything wrong and haven't broken the law, to disperse. And we saw this happen in Missouri during the Ferguson protests after Michael Brown's death, and again during the protests of 2020, as Teddy has explained. So in Missouri, unlawful assembly occurs when a person knowingly assembles with 6 or more other people, and they agree to violate criminal laws with force or violence. Only after a protest has been declared an unlawful assembly can police then order the people there gathered to disperse under a different statute, the state's dispersal statute, which says a person commits the offense of refusal to disperse if they're present at an unlawful assembly or a riot and they refuse to leave. But the key feature of Missouri's unlawful assembly statute is that a group of at least 7 people must be gathered and agree to break criminal laws with force or violence. And that force or violence point is actually pretty important. The requirement that there must be an agreement to violate criminal laws with force or violence means that non-violent lawbreaking like trespassing or loitering by some individuals cannot make an entire assembly unlawful. Missouri case law makes clear that an assembly is not unlawful until it causes a disturbance of public order such that it's reasonable to believe the assembly will cause injury to people or damage to property and will otherwise interfere with the rights of others. So as Teddy described earlier, the practice of declaring assemblies unlawful is what is at issue in our case against the city of Forest. Another case where this was an issue arose out of the Ferguson protests in 2014. In response to those protests, police adopted a policy where they would tell protesters that they had to keep moving. This is the keep moving policy, and that they could not stand still while protesting on public sidewalks. Police weren't given much guidance on how they should go about enforcing that policy, but protesters were told often that they had to keep walking while they were protesting or praying or speaking with other protesters. Many police told people who were either peacefully assembling or simply standing on their own that they would be arrested if they didn't keep moving. Other police officers told protesters they could only stand still for 5 seconds, and if they stood still for longer than that, they would be subject to arrest. This policy was enforced through Missouri's refusal to disperse statute, and some protesters were actually arrested. A lawsuit was filed, and a federal judge determined that the plaintiffs were likely to prove that this keep moving policy violated the First Amendment. The judge also determined that Missouri's unlawful assembly and refusal to disperse laws did not justify the keep moving policy. That being said, if you're ordered to disperse at an unlawful assembly, you can be arrested if you fail to do so, even if you're not breaking the law. For example, if you're at a protest and a large group of people start breaking criminal laws with force or violence, like people are destroying property or burning property, and the police then declare that assembly you're a part of is unlawful, and they then order you to disperse, you are obligated to disperse. And if you remain, you can be subject to arrest. Teddy, was there anything that you wanted to add? I know you're really deep into this issue right now, working on our case, so I know you probably have some thoughts on the issue if you want to share.
Yeah, absolutely. I certainly think that the part of this statute that you've highlighted, that the criminal laws with force or violence is really important to the statute. That's kind of what our litigation has kind of evolved into on the case that I'm working on that I kind of described earlier. The city has taken the position that that language is not necessarily necessary, and that it could be, if you're doing anything wrong, they can declare an unlawful assembly. We certainly disagree that that's true under the First Amendment. We think that the First Amendment really does require a lot more than minor infractions, like, accidentally stepping out of line onto the wrong property or something like that. It needs to actually be a type of violent act. Once an assembly does become violent like that, most people aren't going to want to stay there and actually be a part of that assembly anymore, because pretty much people, when they go out to protest, aren't looking to start breaking things. They're looking to assemble and peaceably express their views. So, that's why that part is really in that statute, is to differentiate between the types of protests where people are speaking their mind and exercising their First Amendment rights, and those those assemblies, I guess, where people are more interested in breaking things. And the police will often try to cross the line and say that even those assemblies that are lawful should be unlawful, because they don't want to have to deal with it. And that's really where the clinic comes in, and where a lot of people come in to try and sue to enforce these laws and enforce the First Amendment. So I think that last part's really the critical piece. As long as you're at a protest and you're peaceably assembling, there's not much that the government can do, not much that the government should be able to do either. So.
Thanks, Teddy. So what should you do if a police officer stops you while you're at a protest? Now, it's easier said than done, but try to remain calm if a police officer stops you. Don't run or argue, even if you are innocent of any wrongdoing. It rarely does any good to argue with officers, especially patrol officers who may just be, don't want to say mindlessly enforcing directives they've received. And in some situations, it might make sense to ask to speak to a supervising officer to explain that, the activity you're participating in is protected under the First Amendment. You are peacefully protesting and sharing views that you have every right to do. That may not save the day, that may not work, but it could be worth it in some situations. If you're stopped, ask the officer if you're free to go. If the officer says yes, don't say anything and just walk away calmly. You're not, as we discussed before, you're not obligated to consent to a search of yourself or your belongings. Even if you withhold your consent, the police may then decide they have reasonable suspicion or probable cause to effect a search. If you are detained, ask the officer why you have been detained and stopped and what crime you are suspected of violating. If you're then arrested, you have the right to remain silent and ask for a lawyer. Remember that failing to obey a police officer and a lawful order of a police officer can constitute a separate offense. So don't physically resist, because that can lead to an additional charge and would just further escalate the situation. Don't sign anything or make any decision without a lawyer. In some situations, you have the right to an attorney free of charge. If you can't afford one, you also have the right to make a phone call. Now, if you're making a phone call to your attorney, the police cannot listen, should not listen to your phone call. But if you're speaking to someone who's not an attorney, you should assume that the police are listening to that phone call. So be careful what you say in those situations. If you're a non-citizen, ask your attorney about the effect of a criminal conviction or a plea bargain may have on your immigration status, and do not discuss your immigration status with anyone but your legal advisor, especially with the police or any prosecuting attorney. Try to remember the names and badge numbers of any officers who were involved in your arrest or detention. That can be important information if you later decide later that you want to challenge the arrest in the future. If you can demonstrate that the arrest violated your First Amendment rights, you should not be convicted because that's a valid defense. What should you do if you feel your rights have been violated at a protest? Try to write down all the information or otherwise document the events that led up to that violation of your rights. I mean, what's commonly done is video recording, because we all have phones with a capability. If you were questioned, stopped, or arrested, as we said, try to find out the name and badge numbers of those individuals who are involved. Try to get contact information from anyone who was in the area who may have witnessed what happened to you. Photograph any injuries you may have sustained in the process of that violation of your rights. This can all be valuable information if you decide to file a complaint with the police department's internal affairs department, or later decide to bring a civil lawsuit. Even if you're arrested and charges were dropped, or you weren't arrested at all, or you weren't even stopped or interrogated, you can bring suit if you feel like your constitutional rights were violated under a federal law known as Section 1983. That law provides plaintiffs a way to sue state actors for violation of their constitutional rights. And I think it's important to remember that you don't need to be arrested to bring a lawsuit challenging a police practice or a municipality policy that might be in violation of the Constitution. Chilling effects are enough to potentially have a viable claim. And chilling effects basically are situations where police activity, police conduct, or a municipal policy has made you fearful of participating in First Amendment protected activity. It has made you think twice about sharing speech or protesting or expressing your way that, if you would have otherwise, absent that police practice, police conduct, or policy. Some other
sorry, just a quick question. What are the most common chilling effect tactics that are used to, prevent people from engaging in their right to peaceful protest?
So one thing that happens a lot, and we've talked about it here, is declarations that a protest is an unlawful assembly. It's commonly done. People might be gathered. The police might decide they don't want to bother with, trying to enforce traffic laws or trespassing laws if a few people are infringing upon those laws or violating those laws. And the police will then decide, we're just going to declare this entire assembly unlawful, and might charge a few people with unlawful assembly or refusal to disperse. And then when it comes time to prosecute that case, the state or the city might just decide to drop it because they know they don't have a valid case. But they accomplished their goal. They got people to leave. They got the protest to end. And that is a chilling effect when police do something and as a result, people leave or stop sharing and expressing their views. Yeah, that's one really common way. Right. Some other issues that come up a lot and people wonder about is whether police can attend protests undercover. They can. There is a police right to attend protests undercover. That might chill people from participating in protests, but you shouldn't let that deter you from participating in protests. And I only mention that to give you some background. If you decide to speak to someone you haven't met before or someone you're not familiar with, just maybe don't admit to any wrongdoing to that person because you may not know who they are in that situation. Police can take pictures of those present at protests. There is a right for protesters to take pictures of those present. Police can do the same. Police can search protesters if they have reasonable suspicion that protesters might engage in some criminal activity in the future. So I wanted to leave some time, we've gone on for a while, leave some time for any questions that anyone may have.
What about social media? Can they use your personal social media account against you?
Yeah, that's often done. It's whatever you post on social media, you should consider as public. It's, as public as if you were standing in the middle of a public square and, loudly declaring whatever you posted there. And police do and have and often do use posting on social media as evidence that someone has violated a crime. It does happen.
Isn't that what happened during the January 6th Capitol riot? A lot of people who were eventually arrested, it's through their social media accounts. They had pictures of themselves in the Capitol and things like that.
Absolutely. Yeah. Federal law enforcement, really parsed Facebook, Instagram, these other social media sites for pictures of people gathered there. And, sometimes people were posting it on their own Facebook site, so it's easy to kind of track down who they were. Sometimes police use facial recognition technology to determine who may have been at a protest. And in the Capitol riot situation, certain law enforcement agencies did use some facial recognition technology. So yeah, whatever is available in the public is something that police can potentially use to build a case against you.
Okay, so we do have a couple of questions. The first one, why is the right to peaceful assembly so critical to democracy?
So I would argue that the right to peaceable assembly should be even stronger than it currently is. And why that is speech is very protected in the First Amendment and our case law. It's not unlimited, but there are very robust protections. Now, what that means is offensive speech, harmful speech, speech that some people may consider hateful is protected. And the idea behind that is, the way to defeat bad ideas is to have more speech, to point out the failures of those bad ideas, to point out how ridiculous hate speech is by countering it. And the concept is if you just try and prohibit it, limit it, you're not really changing anyone's mind. and the concept of the marketplace of ideas is that bad ideas and good ideas can compete, and we're all reasonable, that eventually the good ideas will win out. Now that's great in the speech context, but in protest contexts where, it's not always speech that we're worried about. Sometimes protests aren't just, they don't involve just speech. They involve us gathering together in an area where we can demonstrate that there are a lot of people who support this idea, who want change in this particular area of our society. And it's not just our speech, it's the fact that there are numbers and people have decided to come together to express that they believe in that. And that's not necessarily speech, that's our right to assembly. And when we look at everything through a speech lens, we kind of leave some activity unprotected, like the mere fact that you are gathering in numbers and the fact that you might be, obstructing a entrance to a public governmental building. That is not necessarily speech, but that is your right to assembly. And I would argue that that should be as protected as pure speech is.
Do you think that religious or racial minorities experience discrimination when exercising their right to peaceful protest?
Yes, I do. I do think that often when racial, ethnic, religious minorities are expressing their views, it seems like police presence tends to be a little more aggressive and more present than in other situations. And I think that has to do with a lot of inequities that exist in our criminal justice system and in the law generally. But yeah, it does happen, and we see it happen a lot.
I had a question. When I think of protests, the January 6th Capitol riot keeps coming to mind. What distinguishes that particular gathering from a peaceful protest? Like, why are people in that particular situation being prosecuted and sent to jail versus, other types of protests?
Right. So, one, you have a right to protest on streets, on sidewalks, in certain public plazas and squares, but you don't have a right to enter a governmental building and interfere with how that governmental building should be used. And the Capitol protesters, they weren't just, on the sidewalk expressing their displeasure with the results of the election. They broke into the Capitol, destroyed Capitol property, destroyed federal government property, became violent, harmed people who were present there, other protesters and officers. So that's when protest crosses the line, when it becomes violent and destructive. And it's no longer your speech or expression at issue. It becomes a public safety issue.
And would it be fair to say that this was a situation where there are fighting words being used, there's incitement, like allegedly there are people chanting hang Mike Pence and things like that, where, there was a real threat of harm?
Yeah, I think you could argue, it wasn't maybe not just rhetoric, because they maybe could have actually acted on it. The people gathered there were obviously very upset. It's very, very hard to establish that some speech was incitement. There's, case law where a lot of kind of ridiculous, insane things are said and it's not determined to be incitement. And actually, there was a lawsuit brought against President Trump for statements he made, then President Trump, for statements he made before the riot. And the plaintiffs in that case alleged that what he had said, constituted incitement. And I think that was in the Fourth Circuit, and the Fourth Circuit said, in this situation just doesn't rise to incitement because incitement is such a high bar to meet. But yeah, I mean, I think it could be argued that there could be some of that speech about, hanging Mike Pence could have been incitement.
Oh, here's one. You said that the First Amendment is the hardest working amendment. Can you explain that a little?
Yeah, there's just so much packed in there. There's free expression, the Establishment Clause. So those first two have to do with religious liberties and your right to express your religious views and practice how you want to practice, and the Establishment Clause, where the government can't favor one religion over another, or decide that this is now going to be the state religion. So those two issues are enormous and very core to our values as a country. And it's kind of why it's the First Amendment. And there's so many cases every year in the Supreme Court that involve just those two rights. And then besides the religious clauses, you have all the speech, press, assembly clauses, which are also enormous. Like the freedom of speech is something that people associate so strongly with American values, and similarly with the freedom of press. It's something that we really think sets us apart from other countries, other democracies, and the right to peaceably assemble and petition is also very, very important. It's just that there aren't as many cases dealing explicitly with those last two rights.
I'm
Yeah, because
afraid
you
to
have
ask.
some amendments that are like, you don't have to house soldiers in your home. I mean, that it's not something that is ever done. So some amendments work a little harder than others.
Right. I really liked that description. It's the hardest working amendment.
Yeah. I'm almost afraid to ask this question, but I just want to know, are you allowed to carry a gun into a protest?
I think that depends on the state you're in. A lot of states have open carry laws where if you have a license to open carry, you can do so in public property. I'm not too familiar with open carry or concealed carry laws, but that's my understanding. Some states that's not allowed. Some states it's a concealed carry only. You can't openly have it visible. Now that doesn't apply to private property. Private property, private owners of stores and other businesses, they can set their own rules. But it really depends on the state you're in. And I unfortunately am not aware of what type of state Missouri is, if they're open carry or concealed carry.
Okay. Are non-citizens protected by the First Amendment right to peaceful protest?
Yes. So one of the great things about the Constitution is it applies, if we're in the First Amendment in particular, applies to any person in the United States.
I think sometimes people who are immigrants, who are undocumented, they are afraid to participate in these types of events because they're worried about what might happen to them.
Yeah, no, I completely understand that. It's definitely, something that can be scary because, you don't want to put your immigration status at risk. But you do have a right as an individual within this territory, in this country, to express your views, to worship as you wish, to say what you want, to assemble and protest when you wish.
You want to add anything else, Homa?
No, I think you guys did a really great job of covering the First Amendment right to peaceful protest. It's been very educational and informative.
Thanks. Well, thanks for having us. It was really a pleasure to share some of this with you.
Thank you for doing this.
I know, thank you. This was fun. I learned a lot.
I'm glad.
I think that's all for the questions that we have on Facebook and Instagram. Anything else you want to add, Homa, or?
No, we would love to have you back to discuss other First Amendment issues. We'd love a discussion on the First Amendment right to free speech. there's so much to discuss there.
Yeah.
Hopefully we can do that soon.
Yeah, we'd love to be there.
Yeah.
Great. Well, thank you all. I appreciate it. I hope you enjoy the rest of your weekend.
Thank you so
Alright,
much.
Thank you.